When I forget to put on my specs, it reminds me. Yes, that's what she was saying. We have it. Actual caring comes at a mature age.
मैं अभी अनम्यूट कर रहा हूँ आपको, ठीक है? तो वहाँ पे एनर्जी पर्सन
ये मैडम साथ में नीचे से करा दी नीचे से 1 मिनट में आ रही है मैम आ रही है
Suro reverse.
Okay.
Suro
Time is coming.
reverse. In childhood, mother takes care. And then, of course, in between, nobody takes care. But on the other side of the other end of it.
वॉइस चेक करो, दिख रहा हूँ मैं सामने। आपको सुनाई दे रहा हूँ मैं? अंकित, हेलो।
Removing this, yes. Yes, Mr. Radhakrishnan.
Yes.
At least for the time.
At least for the next 30 minutes, we'll remove it.
It happens every day. When we conduct code, they say, because virtually, I believe what I have found is that we are speaking a bit louder. Not that others are hard of hearing, but because this virtual mode has, in fact, reshaped our anger.
Yeah.
थोड़ी देर बाद होगा सर।
Also, we are speaking.
अभी आपको आवाज आ रही है? ऑडिबल सर?
बोलोगे?
Am I audible?
yes, you are audible. कम है।
Okay, sir. I will just play that video once, sir.
You should play. Yeah, you should play.
अंकित, एक पीयूष भी है वहां पे, उसको भी कॉल कर ले।
Yes, sir. कोई दिक्कत नहीं।
एक उनके बता दीजिए मिनिस्टर इज अबाउट टू ज्वाइन
Yes.
Yeah, this is
So, sir, मैं
okay. Just press it.
गजेंद्र जी हो रहा है?
हाँ, हो रहा है।
हो रहा है। थोड़ा साउंड थोड़ा धीमे आ रही है, आपकी वॉइस धीमे आ रही है।
अब ठीक है।
तरफ से मैं कोशिश कर रहा हूँ।
सर, मैम बैठ के बात करेंगे तो आवाज पूरा आएगा।
एक मिनट, मैं उनका थोड़ा
अच्छा नो क्या था? ओके
आप वॉइस टेस्ट कर लो, गेन बढ़ा रहे हैं।
डोंट डिस्टर्ब एनीथिंग। अब यहाँ कोई नहीं आएगा। यस यस ठीक है। वो तो कर रहे हैं, कोई कर रहे हैं।
अंकित, एक बार वॉइस टेस्ट कर लो।
फुल में कर दीजिए अंकित जी, फुल में करिए।
नहीं, वो FM ऑफिस से।
अच्छा
आपकी बहुत बढ़िया आ रही है,
आवाज भी क्लियर है।
वहाँ से ये है ना 20
आप क्लियर है तो ना क्लियर है।
ये कैन फाइट
increase. It can increase more content.
हाँ कॉल कर दो।
गुड आफ्टरनून।
गुड आफ्टरनून सर। सर, एक बार थोड़ा सा ऊंचा बोलिए प्लीज। GS मोदी बोल रहा हूँ सर।
गुड
Yes, Mr. Modi. Do you hear us?
Is it audible?
Yes, sir.
Mr. Modi, is it audible?
ऑडिबल सर। Sir,
Is it
audible.
audible, Mr.? Okay.
Oh.
Madam will join shortly.
Can increase it a bit more. There's a lot of
Chances in space.
yeah, that is there. It can be volume can be increased.
Matches will go on the 100.
That is Chennai.
Nobody will come. Please. Nobody.
सर ये क्या उसके कुछ टाइम बाद में इसको दिखाना है या स्टार्टिंग से रखना है?
ये एक इनॉग्रेशन होगा.
साउंड किसके इंक्रीज करूँ? म्यूजिक के इंक्रीज करूँ या जो माइक में बोल?
Yes, Mr. Verma, good afternoon. Mr. Modi, are you hearing us?
Yes, sir. I'm hearing, sir. Your voice is okay, sir.
Permissible level of voice, that's 75 decibel. This is not even 40. On that side, on our side, it will be okay.
Please increase your volume. Sorry.
Yes, sir.
Okay.
Contribution.
வணக்கம். கூர்ந்து கண் உணர்த்து திரை புரிந்து யார் மாட்டும் தேர்ந்து செய்வதை முறை என்ற வள்ளுவரின் குரலுக்கு ஏற்ற நடுவுநிலை காத்து நீதி வழங்கும் NCLAT துவக்க விழாவிற்கு வருகை புரிந்திருக்கும் அத்துணை நல்லுள்ளங்களுக்கும் இனிய வணக்கங்கள். திருமதி நிர்மலா சீதாராமன் அவர்களுக்கு NCLAT சார்பாக எங்கள் மனமார்ந்த வருகையை தெரிவித்துக் கொள்கிறோம். Ladies and gentlemen, it's indeed a pleasure to extend a very warm welcome to Srimati Nirmala Sitharaman ji, Union Minister for Finance and Corporate Affairs, Honorable Mr. Justice Bansilal Bhatt ji, Acting Chairperson NCLAT, Sri Rajesh Verma ji, Secretary, Ministry of Corporate Affairs, Honorable Sri Justice M. Venugopal ji, Judicial Member NCLAT, Honorable Sri Balwinder Singh ji, Member Technical NCLAT, Honorable Members of NCLAT, NCLATs, officers and dignitaries of the Ministry of Corporate Affairs and Ministry of Finance, members of the Bar and everyone present here, as well as everyone that has joined us virtually. It's an honor to have all of you in our midst. Today, we reach another milestone in the history of commercial and company litigation in the country. It is both a matter of privilege and pleasure for me to welcome all of you to the inaugural ceremony of this Chennai bench of the National Company Law Appellate Tribunal. The rich heritage of Tamil culture is known worldwide. To quote Bharatiyar, Kalvi Siranda Tamil Nadu, Pugar Kamban Piranda Tamil Nadu, Nalla Palvidamai, Sathiram Manam Parangum Visum Tamil Nadu. It is indeed a privilege for Tamil Nadu to have the NCLAT bench at Chennai. Tamil Nadu has always been in the forefront of commerce and business and has a diversified manufacturing sector and features among the leaders in several industries like automobiles, pharmaceuticals, textile, chemicals, software technology, healthcare, to just name a few. Undoubtedly, last year has been challenging for all of us, but this institution, under the leadership of the Honorable ex-chairperson, Mr. Justice S.J. Mukhopadhyay, acting chairperson, and other honorable members, has ensured that justice was not denied to the litigants, even in these trying times. A bench of National Company Law Appellate Tribunal at Chennai was constituted by a notification dated 13th March 2020. The bench was scheduled to be operational with effect from 18th March 2020. However, due to several reasons, including the COVID-19 pandemic, this couldn't happen. It's a matter of privilege for us to commence another bench of NCLAT, which will cater to matters arising in Tamil Nadu, Karnataka, Kerala, Telangana, Andhra Pradesh, Lakshadweep, and Pondicherry. Initially, Honorable Sri Justice M. Venugopalji, Judicial Member NCLAT, was transferred to Chennai bench of NCLAT. Later on, Honorable Sri Balvinder Singh Ji, Technical Member, was also transferred. It's my honor to extend a very special welcome to Honorable Mr. Justice Bansilal Bhattji, Acting Chairperson NCLAT. Sir, may I request you to kindly welcome the esteemed guests.
Honorable Union Minister for Finance and Corporate Affairs, Srimati NIRMALA SITHARAMAN ji, Secretary, Ministry of Corporate Affairs, Sri Rajesh Sharma ji, distinguished judges, esteemed members of the bar and bench, honorable members of National Company Law Appellate Tribunal and National Company Law Tribunal, learned members of the bar and distinguished participants. A very good afternoon to everyone. It's a matter of immense pleasure for me to welcome Madam Finance Minister and all of you at the inaugural ceremony of the Chennai bench of National Company Law Appellate Tribunal. Today is a momentous day in the life of the NCLAT as its first bench outside New Delhi is born. This bench will have jurisdiction over cases emanating from National Company Law Tribunal's bench at Bengaluru, Chennai, Hyderabad, Amravati, and Kochi, which would cover the states and union territories of Tamil Nadu, Karnataka, Kerala, Andhra Pradesh, Telangana, Puducherry, and Lakshadweep. The need for a uniform code for adjudicating corporate disputes and for reforming the laws related to insolvency of companies and winding up was first suggested by the Eradi Committee, which was set up by central government in the year 1998. This led to enactment of the Insolvency and Bankruptcy Code. It's a transformational legislation as it seeks to establish an ecosystem for handling insolvency and bankruptcy issues to provide an effective mechanism for resolving the insolvency of debtors, maximizing the value of assets available for creditors, and easing the closure of unviable businesses. It has brought about a paradigm shift in the existing insolvency laws and simultaneously provides the framework for time-bound insolvency. Honorable Prime Minister of India, Shri Narendra Modi ji, has very aptly and beautifully underscored the role of the Insolvency and Bankruptcy Code in providing freedom of exit to insolvent corporates. The Insolvency and Bankruptcy Code is a nascent legislation. The Apex Court and National Company Law Appellate Tribunal have settled several conceptual and contentious issues with alacrity thereby imparting clarity to the insolvency resolution process through landmark judgments in cases, some of which are Siriban's case, went to Industries case and Mobilox, which have elucidated the position of operational creditors and financial creditors, benefiting them in a big way. The central government has demonstrated a proactive approach by bringing successive amendments to the code, and government is taking all steps to strengthen the NCLT and NCLAT in terms of number of benches, number of courts at heavily loaded benches, and number of members. 5 new benches have been announced during the last 1 year at Jaipur, Cuttack, Kochi, Indore, and Amravati, bringing the total number of benches of NCLT to 16, including the principal bench. 4 years is too short time to evaluate and judge the efficiency of a legal framework, like the INP code. But it is recognized universally that the Indian legal framework for resolution of insolvency with multiple objects sought to be achieved has emerged as a formidable mechanism, unparalleled in contemporary world. The legal framework assumed the shape of a living organism with speed, emerging as a robust mechanism, which has left many, including some of the stakeholders, wondering as to how the objects sought to be achieved by that proved to be result-oriented by and large within the time frame as set out in the Act. But for the outbreak of COVID-19, resulting in imposition of lockdown and disruption of normal economic activity, the INB code proved to be the most effective legal framework, yielding the intended objective of resolution of insolvency of corporate persons in a time-bound manner, besides promoting entrepreneurship, growth of credit market, and restructuring of the debt-ridden corporate sector. The growth of economy is directly dependent on attracting investments and ease of doing business with an effective mechanism in place for resolution of insolvency. It is flabbergasting that India has remained immune to reforms as far as insolvency resolution is concerned, and the legal frameworks in the sphere in the past did not achieve the desired results. Indeed, the INB code, barely 4 years old, is still in infancy, but viewed from the perspective of objects achieved, it can without exaggeration be called a huge success. The outbreak of COVID-19 having globally impacted economy had its adverse effect on India too. But despite the dark period through which we have passed, we justifiably take pride in disclosing that the march is on. Our pace may have slowed down a bit, but we will reach the goal post with flying colors. Now, when the scourge of COVID-19 pandemic has disrupted the economic processes and production by industries globally, our country has also felt its deleterious impact. The triggering threshold limit for initiation of insolvency resolution process has been increased from rupees 1 lakh to rupees 1 crore from 25th March 2020 onwards. Further, a new Section 10A has been inserted in the INB code by the Second Amendment Act of 2020 that also strives to minimize the impact of this crisis. This has been a very helpful provision brought in by the government to ameliorate the hardships of the corporates in general and MSMEs in particular during this difficult period for them and to sustain them. I would like to compliment the Honorable Prime Minister and Madam Finance Minister for these timely and necessary steps. Important and salutary actions have been taken by NCLAT and NCLT in regard to insolvency action of real estate companies and housing projects, where we have been able to take up and resolve quite a few cases where defaulting real estate companies were unable to provide completed housing units to the long harassed allottees. We have called the process reverse insolvency resolution process. Orders passed by the NCLAT introducing the concept of reverse CIRP in case of real estate infrastructure companies has provided much needed respite to such real estate companies and also simultaneously provide for a time-bound plan that works towards completion of the project and provides possession to the allottees. The Honorable Supreme Court in the judgments of Pioneer Urban Land has expounded a path-breaking concept of considering allottees as financial creditors who can initiate insolvency process. Just a few days back, the Honorable Apex Court has upheld the constitutional validity of the amendments that mandated a minimum of 100 home buyers or 10% of total number of allottees to come together to file an insolvency application. MSMEs are very important players in the Indian economy. IBC has provided them the much needed help by taking quick and effective action under the IBC as operational creditors, where they are vendors of large corporates, and also providing effective resolution when they appear before the tribunal as corporate debtor. We are quite alive to the fact that the livelihood of employees and workers and their families and the money of shareholders and creditors is locked up in the company, and hence sincere efforts should be mounted so that they continue as going concerns. The IBC ordinance of 2018 has brought relief to the MSMEs by relaxing the applicability of the provisions of Section 29A as regards submission of their resolution plans. Today is an occasion to also remind ourselves about the improvement in ease of doing business that IBC's ecosystem has brought in with its advent. We note with great satisfaction that India's overall ranking in the Global Regulation Index has taken a big leap in the last 4 years, improving from 130 position in 2016 to an impressive 63 for 2019. In resolving insolvency parameter, it's an important constituent of the overall ranking under ease of doing business. India's ranking has leapfrogged to 52 in 2019 from 136 in 2016. The improved ranking is due to the reforms, amendments made, and implementations in this code with the approach of the government. The Doing Business Report 2020 has lauded in glowing words India's path-breaking initiatives. The report reflects that the recovery rate under IBC is 71.6%, and the average time taken for effective resolution of insolvency under IBC is 1.6 years. This includes time taken in judicial intervention. The cost of the resolution is presently at 9%, which is expected to reduce further. I take this opportunity to inform Honorable Finance Minister and other esteemed invitees how the timely and effective disposal of cases have helped banks, financial institutions, creditors, and various other stakeholders. As of 30th November 2020, 4,067 applications were admitted for corporate insolvency resolution process. Of these, 518 cases have been closed on appeal, settled. 322 cases have been withdrawn within the purview of Section 12A of the IBC. 1,079 cases have ended in liquidation, and 297 cases have ended in approval of resolution plan. The realizable amount in 297 resolved cases is rupees 1,97,639. It's around 40.31% of the admitted claims. Further, 15,662 cases have been settled before admission involving amount of rupees 5.17 lakh crores. I'm happy to mention that ever since lifting of lockdown, the NCLAT tribunal has adopted virtual hearing from June 2020. 4 courts are already operational at New Delhi, principal bench. And with the starting of the Chennai bench, A total of 5 courts of NCLAT will be operational. We have also now started electronic filing of appeals and applications. I would like to compliment my colleagues in the tribunal for performing the task entrusted to them with full sincerity and dedication. I would like to congratulate and compliment my brothers, Shri Justice Venugopal and Shri Balwinder Singh, who have served diligently in the principal bench and on whose shoulders now rests the success of the working of the Chennai bench. I congratulate the members, esteemed members of bar and stakeholders of corporates who will benefit by the opening of this bench. The opening of the Chennai bench of NCLAT is in consonance with government's effort to provide quick and speedy justice at the doorstep of client. At this time, I am reminded of the words of the first chairperson of National Company Law Appellate Tribunal, Honorable Shri Justice S.J. Mukhopadhyay, who once said, I quote him, I am happy that National Company Law Appellate Tribunal is functioning with speed. For me, speed is of essence for any resolution process. We follow in his footsteps. I once again express my most sincere gratitude to Srimati NIRMALA SITHARAMAN and Shri Rajesh Verma ji for supporting us in the development and further evolution of National Company Law Appellate Tribunal and National Company Law Tribunal. I wish the National Company Law Tribunal Chennai bench a resounding success in its endeavors. Emetola NCLAT bench Erko Enudia Manam Marandaniya Palatuka. Nandri Vanakam Jai Hind.
Thank you, sir. Ladies and gentlemen, it's that time that we've all been waiting for. It's our honor to have Srimati NIRMALA SITHARAMAN ji with us to inaugurate the Chennai bench of the NCLAT. Ma'am, may I kindly request you to inaugurate the Chennai bench of the NCLT. Thank you, ma'am. Thank you, ma'am. I'm profusely elated to take this opportunity to call upon our chief guest, Srimati NIRMALA SITHARAMAN ji, Union Minister for Finance and Corporate Affairs, to address the gathering.
Distinguished Justice Bansilal Bhatt, Justice Venugopal, Shri Balwinder Singh ji, all invited members of the bar, members of the tribunals, guests, and the august gathering of ladies and gentlemen. அனைவருக்கும் அன்பார்ந்த வணக்கங்கள். I'm extremely honored, and I feel it's a great pleasure that today I'm participating in the inaugural of the second bench of the National Company Law Appellate Tribunal, and that too in Chennai. Southern states normally do have this feeling that to seek justice, they travel too far because access to justice in terms of physical access has been always a challenge for the southern states, which are so far and distantly placed, like the way northeastern states feel. from Delhi. So in this context, other than Delhi, to have a bench of the National Company Law Appellate Tribunal in Chennai to take care of the southern states, Karnataka, Kerala, Tamil Nadu, Puducherry, Andhra Pradesh, and Telangana, and also Lakshadweep, I think is a major step forward. And the efforts taken by the NCLAT, in particular Justice Bansilal Bhatt, I thank you very much for providing this access to justice for the companies which are located in far-flung states in the southern region. So in a way, I have a particular sense of satisfaction because being from the southern states myself, I have most often felt that Delhi was too distant for us. And therefore the companies who will have to, and southern states do have a very big achievement to speak of, in that comparable to many of the northern states, southern states and their contribution to the GDP through manufacturing in the south, through the service sector in the south, is a very big success story. Many of the states in Karnataka, Kerala, Tamil Nadu, Andhra Pradesh, IT in Telangana have all made significant contributions, and they need accessible appellate body for the company related matters, and that is what is being provided by this bench. Hopefully the NCLAT will be able to deal with them with greater sense of justice, speedy justice, and so on. So this bench of the NCLAT, like the way Justice Bansilal Bhatt mentioned in his speech, the bench of the NCLAT at New Delhi is to be known as the principal bench of the NCLAT. However, for appeals other than those which are in the jurisdiction of the Chennai bench of the NCLAT alone, the principal bench in Delhi will be handling. So the principal bench of the NCLAT in Delhi will be handling all cases of appeal other than what is being heard by the NCLAT Chennai bench. So in a way, to make it clearer, the NCLAT bench in Chennai does as much and equally as much as that which is being done by the NCLAT principal bench, which is located in Delhi. So the southern states can feel the power of the bench which is being established in Chennai. I think for an audience like this, it's not probably important and necessary for me to highlight the fact that the NCLAT handles matters about corporate law, insolvency and bankruptcy code, and also the competition law. The history of it is very well known that after 1st June 2016, when the NCLAT was established, the IBC code was passed in 2016, and under the IBC, the cases were to be handled by the NCLAT. Similarly, for all those cases which were till then being dealt with by Competition Appellate Tribunal, by the Finance Act of 2017, the Competition Appellate Tribunal cases were also being attached to the NCLAT. So the competition law, IBC, and the Companies Act are all being heard at the appellate stage by the NCLAT benches. And for the corporate sector, which employs more than 58.51% of all the organized sector jobs, it is important that the NCLAT is accessible because it affects the employment of so many people for every such matter related to the companies which seek justice under the appellate tribunal. So I have to very quickly also add the tireless effort made by the NCLAT even during the pandemic. We had, I think the August gathering will be aware that during the pandemic, the government ensured that it granted an abatement of the IBC. Insolvency filings were abated for a certain period, and that was between March 25th of 2020 till 24th March of 2021. So during this period, we had given an abatement just so that people are not dragged to the resolution process during the pandemic times. And even during that time, however, it is important to say that adopting the video mode, the NCLAT has been actively engaged in hearing cases and clearing cases. Nearly 69% of all cases have been adjudicated upon during this time, and that's not easy at all. So I personally record my appreciation for the NCLAT for having adopted technology very quickly and also ensured that the hearings were carried through even during the lockdown and subsequent to the lockdown. That I'm happy to note that the NCLTs and the NCLATs continuing to function in the video mode is noteworthy, that between March 2020 and December 2020, as many as 985 cases were filed, and out of that 681 cases were disposed of by the NCLAT, and that is about 69% of all cases. 985 cases were filed, of which 681 cases have been heard and disposed of, which is, I think, commendable considering given the difficulties during the lockdown and post-lockdown. Till today, there's a lot of difficulty in mobility, a lot of difficulty in staff being in one office or the other. But both the NCLTs and particularly the NCLAT has kept up the work without any hesitation, although they are equally exposed to the pandemic, and duly cleared off that many number of cases. I think it's absolutely praiseworthy. And again, I must say, with the Honorable Supreme Court as the apex forum, the NCLAT and NCLT have done a commendable job before the lockdown as well, and in ironing out many of the issues and difficulties which are being faced in the implementation of the new law. If I speak specifically about the NCLAT, out of approximately 5,600 cases filed with the NCLAT, as of December 2020, approximately 3,800 cases pertaining to just the IBC matters have been handled. And out of the total matters filed before the NCLAT, 4,200 matters have been disposed of. So there is a need for all of us to understand and appreciate the extent to which NCLAT, notwithstanding the fact that they've been in existence only for about 3-4 years, have kept up the pace of disposing cases in time and ensuring the companies are not put to any uncertainty or delay in getting justice. So a word of the NCLT also. NCLT have dealt more than 71,000 cases, out of which 50,000 cases have been disposed of, and nearly 20,000 cases are pending, which I'm sure they'll ramp up to clear at the earliest. So I'm at a juncture when, while inaugurating the new second bench of the NCLAT, to highlight the fact that IBC is contributing and delivering on the intent of the lawmakers, not because of just the law being good, but also those institutions which will have to enable that particular act to be effective in delivering justice. These institutions like the NCLT and the NCLAT in particular are doing their job, and it is because of that that the effectiveness of the law itself is being felt by those who have to be the beneficiaries of such a law. So the intent may be one thing in passing a legislation, but the enabling institutions which will have to make that law effective are the ones who either make or unmake a particular law. And in this case, the NCLAT has done very well for itself and proved that the legislative intent is actually being translated into action and benefiting both the companies and also the representatives and stakeholders, so that institutions and the trust in institutions are positively built up. So we have taken one big step today with the opening of the NCLAT in Chennai. The bench will serve, as I said earlier, Karnataka, Tamil Nadu, Andhra Pradesh, Telangana, Kerala and Lakshadweep and Puducherry. For those of us in the south who normally see Andaman and Nicobar also into this ring of states, I have consciously not mentioned Andaman and Nicobar because they go into the principal bench in Delhi and are not part of the Chennai bench of the NCLAT, and therefore I've consciously not mentioned Andaman and Nicobar. I'd like to thank the state governments also, and I would like to state that we in the government here in the led by the Prime Minister, Shri Narendra Modi ji, is committed to ensuring continued efforts to ensure speedy and cost-effective justice, delivery of justice, and to ensure ease of doing business. Strengthening benches which are both here and in Delhi and in Chennai, and ensuring that timely appointments of the technical and officials, judiciary and of technical members of the tribunals will be done as per the laid out rules and norms. And we hope that in dispensing and also access for justice for companies, both these institutions will perform as they have done in the last few years, and particularly during the lockdown, will continue to perform with the same spirit. And once again, I thank all of you all for being a part of this function today. And this day will mark a greater sense of importance and relief for the businesses which are located in the southern states. And with these words, I present to you all the Chennai bench of the National Company Law Appellate Tribunal. Good luck to all of you all. Thank you very much. Jai Hind.
Thank you very much, ma'am. I'm pleased to request Honorable Sri Justice M. Venugopal ji to extend a vote of thanks to our esteemed guests.
Revered Honorable Union Minister for Finance and Corporate Affairs, Srimati NIRMALA SITHARAMAN ji, Honorable Acting Chairperson of NCLAT, Shri Bansilal Bhatt, Madam Bansilal Bhatt, Honorable Member Mr. Balvinder Singh, Honorable brother and sister members of NCLAT and NCLT, distinguished judges of this Chartered High Court, Honorable members of the Bar, respected Secretary to Government of India, Ministry of Corporate Affairs, Sri Rajesh Verma, directors, officers and dignitaries of the MCA and Ministry of Finance, learned members and staff members of the Bar and officers of NCLAT, New Delhi and NCLT, Regional Director of MCA, Mr. Thirumalai Muthu, Southern Region, ROC Southern Region, and others who have joined virtually and present here physically. At the outset, it is with immense privilege, pride and honor that I am proposing vote of thanks for the inauguration of NCLAT Chennai bench, which would bring the dose of justice to the stakeholders of the southern states and others. I would like to thank the Honorable Minister for Finance and Corporate Affairs, Mrs. NIRMALA SITHARAMAN ji, Government of India, for being instrumental in setting up this court for the South, which has become indeed a reality, of course, with a due diligence and constant award support. Equally, I convey my appreciation to the former chairperson, Honorable Justice Mukhopadhyay, retired judge of the Supreme Court, and acting chairperson, Mr. Bansilal Bhatt, and members of the NCLAT for the unstinted support and cooperation. It may not be out of place for me to make a pertinent mention that lawyers do play a vital role, so to say a primordial role in the wheels of justice delivery system. And with due support from this great bar from which I hail from, and as a judge who had served here for 11.5 years, and also as a judge who had experience of more than 31 years, now serving now in judiciary for 32 years, this institution will strive to deliver timely justice to the needy. Since the time is running short, and as I am given only 2 minutes only, at this time and opportunity, I take this. I personally believe that miracles do happen in life when the Almighty intervenes. And we as Homo sapiens can only be spectators of miracles. And this NCLAT Chennai bench is only a testament to that, coupled with immense support from the Union government, headed by the Honorable Prime Minister, Mr. Modi ji, and Honorable Minister for Finance and Corporate Affairs, Srimati NIRMALA SITHARAMAN ji, who hails from Tamil Nadu, NCLAT, and learned advocates. I take once again this opportunity to thank you one and all who have been present physically and through virtual mode. Thank you once again.
Thank you, sir. Ladies and gentlemen, thank you for being a part of this NCLAT program today. Honorable Mr. Justice Bansilal Bhatt, Acting Chairperson NCLAT, requests all of you to please stay back for lunch. Thank you. Jai Hind.
Proceedings are closed.
The proceedings are closed.
Take the photo.
Yes, congratulations to everybody. Congratulate everybody, Chennai people there, all stakeholders.
Sir, please come this side. Push it up. Close the camera. Close the camera.
Please.